now. Honorable Justice Ravindra Bhatt, Judge Supreme Court of India, esteemed dignitaries of the panel, and my fellow attendees. On behalf of the Law and Technology Society, NLSIU, I extend my heartiest welcome to the 20th session of Consilience. While this conference has been hosted since last 20 years, it is for the first time that it has moved to a completely virtual setting. Among other things, it signifies that tech has revolutionized the society and the way we interact. Since business and law are functions of society, the fast moving tech has disrupted them as well. On account of this, the theme of this year's conference is business, tech, and law. In this interesting interface, the two most prominent subjects are competition law and tech and legal tech startups. In terms of the former, various regulators around the globe are trying to make their law apt to the present circumstances. Various jurisdictions like the US, the UK, Germany, Italy, Japan, Turkey, etc., are trying their best to try different means to regulate tech giants. The Honorable Competition Commission of India has also rolled out various interesting studies, such as those related to e-commerce and the blockchain. To continue this discussion, the first 2 days of the conference will focus on the nuances of competition law and tech. The latter 2 days would move to the second theme, that is the legal tech startups. Since the offices are shut in the pandemic, the legal tech startups have brought in a novel way of conducting the legal practice. Even when the economy was facing the turbulence, these startups experienced a continuous growth and got consistent attention from the investors. Since they seem to be the future destination of legal practice, it becomes essential for us to analyze them. To that end, and without any further ado, I would like to invite Justice Bhatt to inaugurate this 4-day conference with his kind words. Over to you, sir. Thank you.
Good evening, Professor Cremer, Ms. Jyoti Bhanot, Dr. Abha Yadav, and my distinguished co-panelists. A recent US congressional report on antitrust of 2020 October said this on tech giants, that companies that once were scrappy underdog startups that challenged the status quo have become the kinds of monopolies we last saw in the era of oil barons and railroad tycoons. Although these firms have delivered clear benefits to society, the dominance of Amazon, Apple, Facebook, and Google has come at a price. These firms typically run the marketplace while also competing in it, a position that enables them to write one set of rules for others while they play by another, or to engage in a form of their own private quasi-regulation that is unaccountable to anyone but themselves. The subjects for this year's Consilience are particularly interesting and topical, pertaining to technology and competition law and legal tech startups. Over the past decade, the use of technology in the practice of law has increasingly gained prominence, and the changes ushered in by the pandemic have made technology central to business. Thanks to the National Law School of India University and their Law and Tech Society for inviting me to speak at this conference today. The combination of big data with tools such as pricing algorithms is increasingly diffused in our daily life today. A growing number of business entities are using algorithms to improve their pricing models, customize services, and predict market trends. These models provide significant benefits to firms as well as consumers in terms of new, better, and more tailored products and services. This is changing the competitive landscape in which many businesses operate and the way in which they make commercial decisions. Widespread use of algorithms has also raised concerns of possible anti-competitive behavior, as they can make it easier for firms to achieve and sustain collusion without any formal agreement or human interaction. When competition authorities refer to measures of competition in the traditional sense, they typically refer to price, quantity, quality, choice, and innovation. In the context of digital markets, however, the competitive arena is generally different. Price and quantity commonly do not play a decisive role, while quality, choice, and innovation are of greater importance. Additionally, for many data-based businesses, their ability to collect and commercialize data has become a competition measure in and of itself. AI and machine learning have enabled certain firms to extend the type, volume, and sources of data radically, giving them a competitive edge. Many businesses collect and use large, unique data sets. Commonly, it involves consumers voluntarily providing a firm with personal data in return for a free product or service. For example, access to a social media or price comparison platform, which is then financed by selling the data onto other customers, for example, advertisers. Google's and search engine and Facebook social network are two prominent examples of businesses which have employed big data to achieve substantial profits. Predictive models are deployed to estimate demand, forecast price changes, predict customer behavior and preferences, assess risks, and forecast shocks that might affect the market environment, such as the entry of new firms, variations in exchange rates, or even natural disasters. All this is extremely valuable information for improving decision making, enabling entities to plan their business strategies and develop innovative, customized services optimally, not possible otherwise. Use of AI in combination with big data can create economic efficiencies and pro-competitive effects, for instance, by making it easier to identify what customers really need and at the same time reducing the costs of production and distribution. However, under certain circumstances, it is equally likely to contribute to competition concerns, including A, increasing market power and raising barriers to entry, B, increasing market transparency and facilitating collusion, C, giving rise to various exclusionary practices available to dominant firms, and lastly, merger control issues. Where access to large volume or variety of data is important to a particular market, it can form the basis of market power. New entrants are likely to face barriers to entry as they try building up on their data sets to compete with those of their incumbents. New entrants may collect data directly from their customers or may be also able to buy access to customer data from third parties. Where a firm attempts to build these data sets through its own customers, it may struggle if an established firm has already developed a significant network which has won the trust and favor of a significant number of consumers. Equally, a new firm cannot rely on purchasing data sets from third parties as they may not be willing to part with these assets to competitors. Even a firm with low market share, for example, based on revenue, but with access to scarce and valuable data, can have significant market power. The increasing transparency of prices and characteristics of goods and services have a positive impact on consumers, giving rise to more informed choices. For example, online platforms allow consumers to compare prices and conditions offered by its hosted retailers. At the same time, however, the greater availability of information online can also limit competition by facilitating price coordination. In transparent markets, firms can more easily monitor each other's actions, and frequent interactions enable them to punish deviations. Algorithms have now been developed which monitor, analyze, and even anticipate competitors' responses to current and future prices. For instance, in 2016, the UK Competition and Markets Authority found that two poster frame retailers, Prod Limited and GBI Limited, breached competition law by using automated repricing software to monitor and adjust their prices. As algorithms become more sophisticated with machine learning and data sets become more readily available, the prevalence of such online collusion is likely to increase. While it is rare in practice, a dominant firm may also breach competition law if it holds a unique data set, which is essential to a third party's development of new products and refuses to supply that data to third parties. For example, in 2007, the European Court of First Instance found that Microsoft had breached competition law by refusing to give its downstream competitors access to the minimum interoperability information necessary to allow them effectively to compete in operating systems markets. In 2009, the Spanish National Competition Commission fined 4 electricity companies for refusing to provide access to data sets, databases on consumers' supply points to competitor Centrica. Competition concerns are also likely to arise where the combination of two different data troves creates a unique data set which cannot be replicated by competitors and could become an essential input. The European Commission considered this in the Google DoubleClick 2008, Facebook WhatsApp 2014, and Apple Shazam 2018 mergers, but ultimately concluded that it would not create a competitive advantage as the data sets involved, while commercially valuable, were often not that unique and could not be replicated. In the light of growing developments in technology and their impacts on the market, competition authorities have begun to pay closer attention to the effects of AI and big data. For example, the UK's Competition and Markets Authority is currently establishing a new data unit across different disciplines to increase its understanding of the impact that data, machine learning, and other algorithms have on markets and people. In May 2016, the German Federal Cartel Office and the French Antitrust Authority published a joint report on theories of harm connected to big data. More recently, in February 2018, the Canada Competition Authority published a report on big data and innovation, concluding that the emergence of firms that control and exploit data can raise new challenges for competition law enforcement. But the fundamental aspects of the analytical framework, example, market definition, market power, competitive effects, etc., should continue to guide enforcement. The latest French-German competition authorities joint report of 2019 went beyond pricing algorithms and studied the use of study elaborated on the concept of algorithm as well as the different types and fields of application and the categories and categorized them in different ways, several ways. One, by the task they perform. Two, by the input parameters they use. In the involved learning method. In the next part, the study focused on different ways in which algorithms may affect companies' interactions, potentially leading to horizontal collusion. Specifically, this part investigated the use of pricing algorithms considering different scenarios. Firstly, the study covered situations in which the algorithm only comes into play in a step to support or facilitate implementation, monitoring, enforcement, or concealment of a traditional anti-competitive practice. Secondly, the study covers situations where although there is no direct communication or contact between competitors, a certain degree of alignment could nevertheless arise as a result of the actions of a third party that provides the same algorithm or somehow coordinated algorithms to competitors. And thirdly, it analyzed the scenario where algorithms are unilaterally designed and implemented with no prior or ongoing communication or contact between undertakings. Still, the fact that several or even all competitors rely on pricing algorithms might facilitate an alignment of their market behavior, resulting in a mere interaction of computers. Thus, there is a significant shift to my mind while studying the markets and behavior which are driven through algorithms. Perhaps we see the rise of the impact rather than the intent and the impact with some kind of knowledge as about the use of algorithms and their likely effects on the marketplace. Revolutionizing technological tools which enhance how companies operate and interact with each other carry the risk that the same market players use their enhanced power to achieve private interests that are not aligned with social goals. One of the main risks of algorithms is that they expand the gray area between unlawful explicit collusion and lawful tacit collusion, allowing firms to sustain profits above the competitive level more easily without necessarily having to enter into an agreement. For instance, in situations where collusion could only be implemented using explicit communication, algorithms may create new automatic mechanisms that facilitate the implementing of a common policy and the monitoring of behavior of other firms without the need for any human interaction. In other words, algorithms may enable firms to replace explicit collusion with tacit coordination. To address these forms of coordination, some jurisdictions have stretched the concept of agreement for antitrust and looked at whether an agreement can be inferred from evidence suggesting that competitors have not acted independently. Even in the absence of explicit agreement, for instance, courts have established an infringement of competition law if evidence of parallel conduct was accompanied by other factors, so-called plus factors, which indicated that parallel conduct was inconsistent with unilateral behavior and resulted from coordination among parties. Some jurisdictions, in particular those in the EU, also rely on the concept of concerted practice, which allows them to deal with practices that do not amount to an agreement, but nevertheless have the effect of replacing effective competition with cooperation between competitors. Directing the existence of an infringement and proving such an infringement might be complex because the presence of the presence of an algorithm. The challenges for competition authorities, therefore, are primarily in understanding how technology works and how the algorithm can facilitate or support antitrust infringement. Coming to AI and competition law in India, according to a global study carried out by PwC India, the highest increase in the use of AI during the COVID pandemic was in India. AI adoption in India was led by the travel and hospitality sector, with 89% of these firms having some form of AI, telecom, media, and technology firms with 86%, financial services with 82%, and healthcare and pharma companies 73% adopting AI during the year. In competition law, an enterprise is said to have a dominant position in the relevant market if it enjoys a position of strength, which enables it to firstly operate independently of competitive forces prevailing in the market, or secondly, affect its competitors or consumers or the relevant market in its favor. The Competition Commission of India recently noted repositories of data due to unparalleled market base and market power, and that they analyze the data to provide consumers with targeted advertisements, marginalizing other competitors who do not have access to such data. The lack of such access, and costs involved in the developing of self-learning algorithms can create high entry barriers. It has also been alleged that e-commerce entities use data collected from the sale of third-party products on their marketplace to set optimal prices and specifications for their private label products. The CCI has also initiated an investigation into the deep discounting, preferential listing, and market power of e-commerce entities. The CCI further regulates mergers, acquisitions, and amalgamations above a monetary threshold. Competing entities have sometimes resorted to coordinate their production and pricing activities to mimic a monopoly, to increase their collective and individual profits by restricting market output and raising market price. To address such explicit or tacit collusion, the Competition Act in India prohibits anti-competitive agreements. These include any agreement that directly or indirectly determines purchase or sale prices, or directly or indirectly results in bid rigging or collusive bidding. In a recent case on matrimony.com Limited and Google LLC, the Competition Commission imposed a penalty on Google for abusing its dominant position in the online search market. The informant submitted that Google runs its core business of search and advertising in a discriminatory manner, causing harm to advertisers and to the ultimate consumers. It was also contended that Google is creating an uneven playing field by favoring its own services and partners through manual manipulation of its search results. It was noted that in addition to running a search service, Google also provides a large number of vertical search services such as video through YouTube, news through Google News, maps through Google Maps, etc. It was also affirmed that in order to promote Google's own vertical sites, it started mixing many of its results into its organic search results. The effect of this activity is that when a user searches, for example, the name of a song on Google, it receives links to videos of that song from Google Video or YouTube, both of which are enterprises owned by Google. The Commission noted that through the exponential growth of the internet, online markets have now developed an ability to cover an ever-increasing spectrum of commercial activities. Google search engines results were found to be in contravention with provisions of the Competition Act. The Commission also noted that Google, through its search design, not only placed its own entity at a prominent position in the search results, but also curtailed market access to other verticals. It found that Google provided an extended chain in its commercial units, which led the users to its specified search results, Google Flight, for example, resulting in unfair imposition on the users of general search services as well. AI primarily poses three categories of regulatory challenges, namely market foreclosure and related exclusionary practices, novel ways of collusion, and new strategies to effectuate discrimination in pricing. Competition enforcement typically focuses on possible illegal agreement between competitors, anti-competitive vertical restraints such as resale price maintenance, the abuse of dominant market power, and mergers that have the potential to substantially arrest competition. These collusive agreements and anti-competitive conduct envisage an element of human intervention and participation. In the present day, however, we're shifting from a world where executives actively collude to a world where pricing algorithms continually monitor and adjust to each other's prices and market data. So in other words, we are in the era of robo-collusion. Therefore, anti-competitive intent may not exist in the traditional sense. The danger here is not express collusion, but more elusive forms of collusion. It is essential that the legal regime to regulate competition in the market creates mechanisms on a dynamic basis to identify these forms of collusion. Some measures that must be put in place are to increase transparency in the working of companies in the market, increase cooperation between entities for public discourse of the kind of pricing models and algorithms used, and putting in place rules and regulations for handling, storing, and processing personal information. Regulatory authorities need to be well versed in the impacts of the use of different kinds of technology and data analysis tools, as well as the manner in which pricing algorithms function. Greater research is needed in this field so as to frame more informed policies that can be adopted to the quick pace of technological progress, and for the regulator to anticipate and respond to the ways in which firms react and interact with and influence market dynamics. The role of authorities, therefore, in assessing anti-competitive behavior should not be limited to preventing an abuse of dominance, but also include investigating into abusive market conduct of a firm which is in a position of imminent dominance. The CCI should be empowered to look into these situations as well. It is important for competition authorities to be wary of the fact that online platforms not only provide technological infrastructure to connect service providers to buyers, but to engage in pricing by funding price discounts for products listed on the platform. It has been alleged that platforms refuse to share consumer data with service providers. and rather utilize this data to set up their own services and product at a competitive edge. This has been seen in the kind of cloud kitchens, platform-based product, etc. The CCI should, in its investigation of anti-competitive conduct, also take into consideration practices of deep discounting and cashback offers. The test of recoupment can help the CCI to determine which discounting practices will harm competition, and preventive measures can be taken to avoid such harm when the player gains a dominant position and uses it to recover incurred losses through initial discounting. Finally, therefore, the competition regulatory regime would have to keep up with this rapid changes in the technology accordingly. A word on the other subjects, since I have spoken mostly on anti-competition. The use of technology in the practice of the law is increasingly relevant, whether it is in the form of online dispute resolution by large businesses or legal tech startups. With the increasing use of technology to assimilate and review contracts, review legal documentation, etc., the focus, as ever, should be on lawyer-client confidentiality requirement, and accommodations should be made for exercise of human agency to take into account each client's specific needs and offer the most responsible legal advice. The practice of law and the traditional functioning of courts has much to gain from use of technology. During the pandemic, we have seen how useful video platforms have been for online hearings, enabling most courts in the judiciary to function practically through lockdowns everywhere. Additionally, we have also seen the era of digitization in the truest sense, where the platform used is a comprehensive one, both in the video as well as the digital format for the files and documentation. Many judges have now taken to the digital or electronic files and resort to their hearings without the use of or aid of paper at all. The availability of e-files makes it easier for judges to read and prepare for hearings, and access to online databases and case law search platforms is useful not just for research, but also during hearings in the courtroom. Technology can also be used in efficient ways to manage judicial dockets, identify priority case types for urgent listing and case management, deployment of customized AI tools for research and enhancing access to justice. In adopting technology to aid the functioning of the judiciary, our policies must be considerate of litigants and lawyers who may not have access to such technology. We have to be cognizant of the fact that in India, there is a vast digital divide. Therefore, it is important to accommodate that these contingencies, and technology that is used must be accessible as far as possible. Furthermore, there ought to be realization that in the real world, the discretion of humans, often seen as constraining, is the strength that centuries-old practice has honed the application of law to individual cases. The uniqueness of such dimensions and the room for the outlier, the nonconformist, is that it injects the rule of law with the promise of progress. Technology and deployment of algorithms and AI is based on patterning and replicating past behavioral trends. The over-dependence on this as a panacea or a magical wand exposes society to the danger of iteration of all those prejudices and biases which civilizations have grappled with and striven to eliminate in the past 2 centuries. Therefore, these tools must aid judicial functioning and accessibility and not create ground for further exclusion. It is said that you must welcome change because it is the only constant in life. Yet change is only the rule, but not as your ruler. Thank you for the patient audience, and I hope that some of the issues flagged here today will be discussed in greater detail in the panel discussion towards constructive solutions and brainstorming on the emerging challenges that AI and technology have thrown up for law and business. I once again thank the organizers of Consilience and NLSIU for kindly inviting me to this to deliver this valedictory address.
Thank you so much, sir, for the enriching inaugural address. It was very interesting, and I think it flagged really important issues. I think this is the right time to dive deep into the panel discussion. So with that, I leave the floor open to Mr. Aditya Rathod to take the discussion forward. Thank you.
Thank you, Harshit. I was very intently listening to Justice Bhatt and the various examples he had given. And before I introduce the esteemed panelists here, I just want to recapture one example, which I think would set the context for the discussion we are about to have. Justice Bhatt spoke about how Google, when you search on something on Google, the ads which come there at times, they are somehow promoting those services, those products which are owned by Google. Whether it is in case of videos, you will find something from Google Videos or YouTube, or in case of flights. Imagine if you were to use some other web browser and search engine and not Google Chrome and Google. Would the results be same? I actually carried out this experiment and the results were not the same. I know a lot of us are used to Google. The number of people who use Google is immensely high compared to any other search engine. But just for fun, you should all try this experiment once. And I think this will make relevant the discussion topic for this panel, which is dominion over data and analysis of modern market supremacy. So without much ado, let me please introduce the distinguished panelists here. We have Ms. Jyoti Jangar Bhanot. She is economic advisor to CCI. We have Dr. Abha Yadav. She's a professor at Indian Institute of Corporate Affairs. We have Mr. P.K. Singh, who is the CEO for Government e-Market. And we have with us Professor Jacques Cremer. I'm sorry if I'm not pronouncing it correctly. Professor Jacques Cremer, who's from Toulouse University. And we have Professor Rahul Singh from NLSIU. Welcome, a very warm welcome to all of you. I think by giving that example in the beginning, I've already made it clear what we are going to discuss. So regarding the format of the discussion, for the convenience of the audience, I will be asking a question to individual panelists. And I would request the panelists to respond to that question. And then I will ask other panelists if they have any additional comments. So my first question is for Ms. Jyoti Jangar Bhanot, which is, when we say that data is leading to some sort of dominance, some sort of supremacy in market, this is a recent trend, of course, recent phenomena, because data-driven companies have become much larger than they were, let's say, about a decade ago. So could you, with the help of some instances, explain to us what does it really mean?
Thank you, Aditya. It's a real pleasure for me to be here today. And I thank the Law and Technology Society of NLSIU for giving me this opportunity to contribute to this dialogue on a very pertinent and contemporary issue of interface of data with the competition law. The competition dimension of data has become even more pronounced on account of increasing dependence on digital modes in every sphere of life in wake of the pandemic, and I believe everybody would agree with that. Digital economy has revolutionized the way data is generated, stored, processed, exchanged, and distributed, and it has led to emergence of new possibilities and business models. On the one hand, this revolution has brought efficiencies, significant benefits, economic opportunities. On the other hand, it has brought to the forefront the potential of market power abuse, due to aggregation of data at massive scale, which may be concentrated with a few players. Now, in order to appreciate this intersection of data and dominance, it is first important to understand what dominance under competition law means. So the concept of dominance is generally rooted in market power, namely the ability to act unilaterally without being constrained by competitive forces. Pertinently, there has been a paradigm shift in the legislative thinking, whereby, unlike the erstwhile MRTP, where size itself was frowned upon, the present law only targets the abusive behavior of dominant undertakings. The present law provides a robust framework for assessment of dominance in terms of various factors which have been provided therein, such as market share, resources of enterprises, consumer dependence, vertical integration, entry barriers, to account for data as a source of market power. To begin with, control over data stands subsumed within resources of the enterprise concerned, besides having intersection with other factors. Further, the law, being futuristic, also provides flexibility to the regulator in accounting any other factor, such as network effects, switching costs, etc., which are very typically associated with new age markets, have very close nexus with data, to account for these in undertaking such assessment. Now, for understanding the positioning of data in this entire complex matrix, it is very important to understand that what are the attributes that have transformed data as a critical asset and resource at the disposal of enterprises. Why it has become like a new gold and a new oil. So these can be clustered as 5 V's, comprising velocity, which refers to the lightning speed at which vast amount of data is being generated, collected, analyzed on real-time basis. Volume, which refers to incredible amount of data which is generated each second. Value, meaning thereby the ability to turn into something that has a purpose, use, merit, and can be monetized. Variety refers to different types of structured and unstructured data which lend themselves to being harvested in diverse ways. And veracity, the precise and accurate nature which renders it useful for undertaking commercial decisions. And recently, of course, 2 more V's have been added to these 5s, namely variability and visualization. So it is these qualities which convert data into what has now been known as the big data, and is normally very usually referred to on all discourses related to data and competition. So now in digital markets, there is no doubt that data can have a very transformative force in delivering goods and services to consumers in a very efficient and customized ways. So having said that, against the background, now let me give you some instances highlighting the potential of data as a source of market power based on the cases which we have handled or we have observed internationally. Of course, I will avoid mentioning any specific cases and rather focus on the issues which are on the table in the context of data and antitrust law. So a platform with a large base of users is able to collect more data to improve the quality of the service, for instance, by creating better algorithm. And this way to acquire new users, what is known as the user feedback loop. On the other hand, due to multi-sided nature, platform is able to monetize data through targeted advertising, which kind of gives it revenue, and these funds can be used to invest in quality of service and attracting even more users, which is being referred as the monetization feedback loop. So the global experience has shown that these loops can make it very difficult for a new entrant to compete against an incumbent with a large base of users. Data therefore plays a critical role in reinforcing the incumbency advantage and thereby contributing to dominance. And the strength of these effects and the extent to which they may prevent entry, however, will depend on the specificities and dynamics in terms of feasibility to replicate data, portability, interoperability, and multi-homing options in the market in question. Absence of portability and interoperability may imply high switching costs and exist barriers for consumers, thereby translating into corresponding entry barriers for other market participants. So the relevance of such accumulative data and ability to employ such data in a versatile manner across verticals and purposes may further reinforce and expand the market power of a platform to other markets, which could be the neighboring markets or even unrelated markets. So this entire thing may result in a scenario and create an ecosystem where few players in the market, by virtue of having control over a huge amount of data, may capture the entire interconnected digital ecosystem in the market, giving them potential avenues for abusive conduct. So overall, data, I hope you will all agree, plays a critical role at every stage of antitrust enforcement, be it delineation of market, ascertaining dominance therein, and examining the abusive conduct. This, of course, requires understanding of the structure of the market, underlying incentives of the players, and implication for users to ensure that unduly innovation is not stifled, and at the same time, we are able to address market distortions. Thank you so much.
At this stage, I think I have a larger question for everyone. First, data is the new oil. This is something we've been hearing for the longest time. I think Google example I've already taken, so I don't want to I don't want to use that example again, but I have a request if perhaps other panelists can point out in what all other ways this dominion of data could be seen as problematic. And these could be cases from India, from abroad. Google is just one of them. I mean, I'm sure if someone was to do a quick search when it comes to anti-competitive suits, antitrust suits, Google would probably appear in every single jurisdiction. But what are the other examples that we can think of? The reason why I'm asking this question is because I think all of us understand the idea of abuse of dominance or the idea of dominance, but to contextualize it in terms of data is something a lot of us probably cannot grapple with. So it'll be helpful. So if someone would like to give an example of dominion of data. Okay, I think I'll have to do cold calling here. Okay, thank you. Thank you for volunteering.
So I'm not sure this is going to answer exactly your question, but one thing you've got to remember is that one of the problems with data is that it's social, it's not only individual. And so if it was only individual, if I didn't like the way in which Amazon was using my data in order to give me advice or to price things for me and so on, it would be very easy for me to go and see another firm. I would lose, I mean, in lots of jurisdictions like Europe, you've got data portability. So I could ask Amazon to transfer my data to whatever other marketplace. And I would accept a little transition while the new marketplace doesn't know how to use my data as well and so on, but the cost would be only individual. Okay. One of the issues is that data also has strong aspects of network externalities, which is that the data that Amazon uses in order to decide what to show me is not only the data they have about me, but the data they have about everybody else and what people like me have used and so on. So there's a very important aspect we need to remember when we think about data. It's not a collection of individual data. It's really an aggregate of data, which makes it much harder for individuals on their own manage their data, because on their own, your own data is not really very useful to lots of platforms. Okay, and I think that's you know, why Professor Jingar's analysis was very good, because this is what creates the dominance. It's this collective nature, not the fact that it's individual.
I have a question for you specifically. And just because of the conversation that we were having about data and the concept of dominance was being explained in context of data, do you think that competition law, the way we understand it right now, antitrust law, the concept of relevant market, these concepts which are related to competition law, are they, do we need to change them, expand them, rethink about them, or do you think they are sufficient at this stage to be able to accommodate the concerns which are being raised by tech-driven companies?
So do you want the short answer or the long answer? So will you give me 5 minutes to answer this question? Because
I shall.
Okay. I think it's useful to, when we think about market definition, to step back a little bit and understand why market definition was introduced in competition law and practice. Okay. I don't know enough about Indian competition law, but in none of the laws I've ever seen is market definition part of a law. It's part of a case law. It's not part of a, it's not in the statute. Okay. Now, markets in themselves are an abstraction that economists invented at the beginning of the 20th century. Okay. And you know, somebody like Marshall said, oh, we can think about the market for wheat. We've got lots of producers. There is a price of wheat and people react according to this price. But this is totally an abstraction. I cannot show you what the market for wheat is. So then, you know, as competition law and practice developed, there was a need to organize, you know, the way in which we went to apply competition law. And people began saying, well, yeah, oh, you know, you are a monopolist and you've got lots of power. And so finally, economists had a tendency of telling their lawyer friends, look, why don't we first define a market? So we define the market for wheat, and then we can see what practices from an agent in that market, who is affecting. Okay, and so there's all this thing which was developed in order to develop market, but the way it was thought of was in the context of those traditional markets, and people have learned how to do econometrics, estimate demand and supply curves, and so on to look at the extent of the market. So now we find ourselves in an economy which has got very new rules, which we don't understand very well. Okay, in lots of cases. Okay, and in particular, for a market economy, we have ways of thinking about the interaction between all the elements of the economy. I mean, they are not perfect. An economy is much more complicated than any model, but we have a way of thinking about it which makes some sense and gives some approximation. We don't have this for the digital economy. Okay, hence the concept of market, in some sense, doesn't really exist. Okay, and actually, the real markets now are markets which are totally artificial. You know, Amazon Marketplace, but that's not, you know, what we mean when we're speaking about competition. So there are some things for which the traditional view of markets works perfectly well, even in the digital economy. So, for instance, if I may take a French example, yesterday or the day before yesterday, the French competition authority kind of came to an agreement with Google. Google wasn't declared guilty, but you know, came to an agreement with Google about the advertising stack and the way the advertising worked. And on this thing, there is a market. You can say, well, there is a market for people who provide advice to advertisers on how to do this. There's a market, and you could define a certain number of market because Google, in this case, was providing services to individual users. Okay. there are other cases in which it's not clear at all what the market is, okay? And in particular, when we think about two-sided platforms, okay? Because what you're doing in a two-sided platform is you are selling, so a consumer in a user on one side of a two-sided platform is also what's being sold to the other side of a two-sided platform and vice versa. And therefore, it's not a market in the traditional sense, okay? We don't have prices, and hence we cannot use the same definitions. And those of you who've tried, for instance, to read the Supreme Court case about American Express and whether or not there was one or two markets, you realize that you look at this and you think, this is nobody can understand it. Okay, it's also complicated by the fact that lots of two-sided platforms, sell several services at the same time, and those services they cannot sell only one of them. One service attracts people and so on, so it becomes very, very complicated. So in those cases, I do think that we have to redefine. Okay. I mean, not even sure that thinking of market definition is useful, okay? So my recommendation when you want to think about it is do an analysis of what's in front of you without thinking in terms of market, okay? And then, because the law forces you to do this, go back and try to retranslate this in terms of market, okay? Now that's a total distortion, because the reason we had invented a market definition was in order to help the analysis. But I think there are some cases on which we really can't do this anymore, okay? And so, yes, we need to redefine this, and it's a really very, very messy area in competition. And I'm sorry to have been so long.
So, Professor, correct me if I'm wrong. What you're saying is that the traditional understanding of market is it works in some way when you talk about digital economy, but we haven't understood digital economy completely yet. So some definitions which worked earlier may not work, and we are discovering it slowly. Am I right if I say this?
So I don't think we're discovering it that slowly. I mean, because, if you've read, I don't know, if you followed the Twitter feeds on the market definition in the Apple Epic case, I was reading this and I was thinking of doing some kind of a collective gift to the judge of painkillers, so that headaches could be. So yes, so there are no markets in the proper technical sense of the term in the way in which we had invented them. Okay, so but there are sometimes where there are markets. Okay, so we can't just say, oh, there are no markets. Okay, just look at the case. Think, does it make sense for me to think about it as a market? Think of a market for wheat or something like this. Does it, or advertising services? Does it look like a normal type of market? Okay, which I could see outside of the digital world. If it looks very digital and very platform related, in the sense that there are two, the interaction between the different agents is primordial, then I don't think that you really have a market. Okay, so you might want to speak about markets because you need to for legal purposes.
Right.
But I'm a humble economist, and although I don't know if any economist is humble, I can see everybody saying. I'm just an economist, and for me, it's not what I think about when I think about markets.
Okay. So I just want to remind audience that Professor Cremer is an economist. So this was an economist's perspective, and he said that digital economy is something which is very different from what we understand economy in terms of what was, I would say, before 2000. The world has changed drastically. I would now like to go to lawyers. Let me go to Professor Abha Yadav and Professor Rahul Singh. And I want to ask the same question. I'm just trying to rephrase it slightly differently. And I would like to know the lawyerly perspective on it. How do you see data-driven companies gaining dominance and abusing dominance? And what challenges do you foresee for the present competition law? Like, does it require any change in understanding of concepts? This is what I asked Professor Cremer earlier, and I'm asking you, and I want a lawyer's perspective on this.
Thank you, Aditya. Professor Rahul Singh, if I may, since both of us.
Yes, of course. Please go ahead.
Yeah, thank you. And Aditya, I have had my hand up for a long time, so I will take you on your first question, which was, so without naming the cat, you've been talking about self-preferencing. And, so the context in which you asked your earlier question was that of self-preferencing, and you asked for an example. And the academician in me cannot, let that question go. And I would like to, for the benefit of the audience, first of all, I think we all need to understand what Professor Rathore said very, very rightly, which is a very unique problem. And I think antitrust agencies across the world are trying their level best to sort of tame the cat of self-preferencing, which in the simplest terms means prioritizing products of your own enterprise in comparison to those of your competitors. And since we're talking about data and big data, it is, more and more we find that how much ever we try to control the big giants, the big tech giants from doing so, it's kind of a very, it's kind of difficult to do that. And one of the best examples of such behavior can be seen in the article Alexa Fund, which was published in the Wall Street Journal, where Amazon funded the research project of Nucleus, where researchers, in the field, in the voice recognition area, and it was assured, despite reservations from the promoters, that Amazon might replicate their data. But Amazon promised that that would not be the case. So once the information was shared by Nucleus with Amazon for funding, within a year, Amazon Echo was launched, which had incorporated much of the features of the Nucleus. The promoters, of course, had no choice but to give in to Amazon merely due to the sheer size of the firm and the inability to compete with such a huge corporation. In fact, if I can recall correctly, another example could be the Quiddity hostile takeover, where again, Amazon had monitored the baby products that was sold on its platform and had forcefully acquired diapers.com after an ugly, ugly price war, which involved undercutting the prices and forcing Quiddity to sell its businesses to Amazon. So, in fact, during the hearing, Mr. Jeff Bezos had accepted that promoting own products, that is self-preferencing, is general business order. And also he said that Alexa might be promoting their own products over others. So yes, this is a common feature and very, very difficult to sort of tame. And to come to your current question, yes, I do have some points to make there also. But Professor Rahul Singh, would you like to pitch in before we elaborate on this?
No, you go ahead. I'll come in after you. Thank you.
I think what you've been asking is that, in this entire, scenario of abuse of dominance and in the the data, big data that exists. And Jyoti ma'am has already said that, big is not bad principle is very much established in today's times as a fundamental tenet of competition policy. So this is something that we are all on the same page about, that big is not bad at all. But there may be various reasons for an entity's large size, right? I mean, and now we realize that it could be due to more efficient operations. It could be as a result of innovation. It could be a novel business model, which is why the entity is big. So in other words, it can be the reward for aggressive competition and fair market, which is what we're all aiming at, and which is something that is beneficial for consumers and for economic productivity. Now, all of this traditional knowledge has sort of taken a toll, if I may say so, with the advent of digital platforms, and various traditional notions are, of course, getting challenged because of this. Now, in my humble opinion, I feel that while competition law across the world has established legal and economic frameworks for assessing abuses of dominance in a digital market, however, I feel that it is not possible that competition law frameworks can address every digital market policy concern. You see, because the concerns are so huge, vast, and varied. And I think that alternative competition policy tools, there could be something like merger control, advocacy, could be more appropriate in some cases. And even in India, they are being used for sure. Now, further, some concerns may not be easily addressed within a competition policy framework at all. So one can say that the debate about abuse, abuse of dominance and abusive conduct by large digital firms is therefore a microcosm of the broader discussion about competition in digital markets. And I think Professor Rahul Singh, with that, I leave this part to you, and I can come back onto this again. Thank you.
Sure, thank you. So Aditya, to unpack your two different questions, one is on relevant market, the other one on data, right? I'll be very brief here. So unlike what Jacques mentioned, actually, I think the Indian Competition Agency might not really have a discussion about the definition of relevant market because it's there in the statute. Of course, we understand that, we just heard a Supreme Court judge in many different contexts, I suppose. Supreme Court itself might not really look at the letter of the statute. But I suppose jurisprudentially, we do understand that, the moment something is written in the statute, it has a certain normative binding value. So in that sense, very quick jurisprudential answer would be from theories like exclusive legal positivism. To me, it looks like unlikely scenario that CCI will have that discussion about not defining the relevant market. Now, of course, see, after defining the relevant market, what they do is it could be either they find an infringement or they don't find an infringement. But to say that somehow they will not define the relevant market might be too difficult a proposition, at least jurisprudentially speaking in Indian context. So that's on the first point, Aditya, that you spoke about. The second point that you have raised is on data, right? Now, with all analogies, I suppose, this data is the new oil also. Although it sounds very good to ears and all, but I'm not very sure whether the analogy is accurate at all. I'll tell you why, and I've said this elsewhere, of course, borrowing from Supreme Court of India judges, although I'm not a judge, I'll self-cite, I've said it elsewhere as well, which is, see, oil is found, right? Data is not found, data is created. So let's say, for instance, organizing this conference, right? All of these students in LTech, they have worked very hard. There are right now 132 participants, which possibly includes all of us, right? Now, organizers have their email ID and their designation, right? Now, should I give it to Aditya because he's in a private university and we are a public university? Aditya will say, can I send an email to each of these because my admission is just coming up, right? So you will say that, listen, you have data, why are you not sharing? And we will say, but what have you contributed to it? We have created this data. It's not oil. Although, people might repeat this ad hominem, but data is not oil at all, in my opinion. Data is something which needs hard work. It needs to be created. It also needs incentives, frankly. If I don't have an incentive to create a data, why will I invest my time and energy into this data? And therefore, my shorter answer there would be, yes, all of this sounds very good, but I don't see data as the oil at all. I think it's something which needs to be seen from the law and economics perspective of incentives. Let me stop over there. I'll, of course, come back to other questions. These are my short, quick thoughts.
Okay, thank you. At this stage, I think we've been talking about how data companies or organizations which have access to data, they are probably using it to gain a dominant position. And it's of course a separate story whether they're abusing the dominant position or not. But there is other side to data as well. I think data could be put to some good use also. Now actually I would like to go to Mr. PK Singh, who's CEO for Government e-Marketplace. For those of you who don't know about Government e-Marketplace, public procurement, Government e-Marketplace is like the one-stop shop for all public procurements, which are to be done by various departments of the government. Okay, so the questions which I have actually 2-3 questions, so I'll just ask them one by one. So first of all, I would like to know, in your experience, does high access to private data by firms pose competition related challenges in public procurement in the first place? Mr. PK Singh, you're on mute.
Sorry, it happens so often. I'll just give you a small background of GEM. I mean, you were kind enough to mention about GEM, but then GEM is a digital public platform which enables government buyers across ministries down to the level of villages, panchayats, urban local bodies to come on a common platform and transact. Now, it's something like Amazon or Flipkart, but the only exception is that the buyer side is only government. Okay. So it's a G2B platform, and since public procurement involves taxpayers' money, government buyers cannot simply add something to the cart and pay for it. I mean, which is where there's a complex set of rules and policies. We have GFR of the finance ministry, which has to be followed, inbuilt into our process. And let me tell you, just share a flavor of the figures we're dealing with. We have done, since the last 4.5 years, business close to $15 billion. In the last year alone, we had done about $5 billion, close to 40,000 crore. And we have connected almost 1.8 million sellers of different capacities with about 52,000 buyers on the government side. Now, yes, high access to private data by firms does pose competition-related challenges, but in our case, it is slightly different. I mean, what we do is, it takes a different shape and form. This problem is not comparable to the competition issues in the larger market, where firms have the competitive advantage of using big data to track customer preference or market trends. The high cost of access takes the form of entry barriers. I mean, the way we operate, is it providing any entry? Is it offering any entry barrier? I mean, we look at that. Hence, the challenge is not so much access to private data as it is access to information about government bids and demand. And the way the platform is structured, this thing is taken to, it is settled very nicely, in the sense that whatever information is available for a particular sector is immediately shared with all the sellers, be it big or be it small. But yes, having listened to the discussion so far, there's a huge power in data, both abusive as well as useful. I mean, we deal with the useful part, so we know how much abuse can also be associated with it. And let me tell you, I mean, I'm not from a legal background or from economics background, but then the way the pace at which it is changing, the way AI and ML are becoming the order of the day, and it's like growing exponentially, and we can't even think of the use it can be put to. The practitioners of competition law and perhaps those who deal with antitrust issues, they need to be equally equipped, to even understand the cases of abuse. The way it is done, the visibility of abuse is also going down, I would say. I mean, the thing is so nicely laid out that you wouldn't even know that you are being used. I mean, just for example, these portals, I won't like to mention names here, but then they actually get into your nervous system. They make you dependent upon them. You repeatedly go like, the mice in a psychology experiment, you repeatedly go onto these portals, I don't know how many times a day, because of something they have done by analyzing what all things you view, what all things you do, and then put it all together through a nice algorithm based on AI, and then judge that this is exactly what you want, and that is what is offered. And then you again and again visit the same platform. So the abusive power is immense. Coming to public procurement, how it can affect the, what all we do. I mean, one of the primary reasons why government e-marketplace was set up was to bring in transparency and inclusivity. Now, as you said, does it pose any problem for, all the players in the market?
Yeah, smaller players, smaller businesses compared to larger firms.
Yeah. So, I mean, just to give you a flavor, almost, close to 1.8 million small companies are associated with the platform and offering goods and services. Now, getting these people the right kind of information along with the larger players is itself a task, which we do it very appropriately. We also do some analytics, big data analytics, and we get to know whether there is any kind of market discipline being violated or not. So, for example, today GEM is almost, as I said, about 7 lakh, not 1.8. 1.8 is total amount, 7 lakh MSC sellers. And these guys end up contributing about 60% of our value. That itself proves that there is no entry barrier of any kind. And the numbers are going up by the day. The number of smaller players, smaller artisans, weavers spread across the country is increasing by the day. And yes, how we do good data usage is, when we try to promote a sector. For example, we took up an initiative of promoting bamboo products. Now, there is something based on our philosophy of inclusivity. We want the bamboo, people who produce small handicraft items and utility items of bamboo to come onto the marketplace and engage with the government buyers. So we can, set up a nice page for them, give them more visibility. So that is how you can fulfill the concept of inclusivity by using data in a manner. You are bringing them more closer to the government buyers compared to others. So different ways are there. And having said that, I'll repeat that the kind of information that we are sitting on right now, it makes us really nervous as to if you want to do it in the wrong way, what all you can do.
Right. In fact, this was a very interesting comparison you made in the beginning. GEM is like a marketplace where only government is the buyer, of course, through various departments and at various locations. And there are various suppliers. And you can compare it to Amazon, where, of course, Amazon is the aggregator and it is ensuring people can buy things which are being supplied through Amazon. But when you say the kind of information you have and how dangerous it could be, I think it speaks of the concerns which are there regarding big data. This, of course, is an example where data analytics is being used in public procurement. By the way, for those who don't know, public procurement amounts to almost around 20 to 22% of the entire GDP of India. I don't know if I have that figure exactly correct, but that's a huge number. That's a huge number, right? And data analytics, data is playing a big role over here. In fact, I think it won't be wrong to say that in a way, GEM has dominance over the public procurement, the data which they have. Thank you so much for the insights. I want to return with some other questions about related concerns which come with competition, issues regarding competition law, concerns regarding privacy. So my question now is directed to Professor Rahul Singh and Professor Abha Yadav, that competition law has a different kind of goal in its mind when it is trying to prevent the abuse of dominance. But when it comes to data, another concern gets clubbed with this, with it, which is basically protection of privacy. Now, there was a question which I just saw. Someone had asked that, it is possible that various apps, they track your habits and they keep supplying information, send videos, or keep showing you material which they know you like to make you addicted to them. Okay, so is this not something which competition law should be concerned about? Because clearly there is an invasion of privacy happening where your data is being used against you and you're not even aware of it, which is something which was mentioned a little bit earlier. So what are your comments on it? I'll go to Professor Rahul Singh first this time.
Okay. Thank you. So if I can make use of Zoom-based technology very quickly, I'll put a share screen, all right, which is, I was listening to your question here, very interesting question. And this is a paper on SSRN, by the way. This is by Professor Pinar Ackman, teaches at University of Leeds. This is still an SSRN paper, but quite an interesting sort of idea, which is there is a data about questions on data, right? Which is, so Aditya, your point is, how many of us are really aware of what we're doing? Interestingly, the data set also includes India. Normally we are all ignored by the Western scholars. This paper, I think, is quite interesting because it has some data set from India as well. But very quickly, this is a very interesting sort of data set in figure 9 over here. I of course encourage all of you to see this entire paper with the caveat that this is not published yet. There are 50 pages here. I'm just showing to you one of them. The idea is, very quickly you can see because of these different colors, excuse me, is that there is certainly a multitude of choices that people have, right? And this is something which they're quite aware about the choices. which technically is seen as what is called multi-homing or multi-homing, right? Which is like each one of us, I'm sure last few months you would have seen our friends and relatives kept on asking us on WhatsApp to switch to Signal for all sorts of reasons, right? Of course, some of us did, maybe some of us didn't. But one of the reasons was, I suppose, Aditya, what you're mentioning is that, are people aware about their privacy issues? See, I don't know, is there enough data to indicate that they are not? Because sometimes our default norm is to believe that somehow they are not aware of privacy, right? So either way, because we don't have an empirical evidence either way, I would think that at least, a paper which has tried to find some sort of empirical evidence can guide us, right? And let's assume that we don't believe in the findings of the paper. I would suggest that what Dr. Abha Yadav mentioned, which is that, the alternative methodology which the Competition Commission in India has is of competition advocacy, right? Which is, and this is not to say that the commission has not used, it has used it very extensively. You would have seen off late, in pharmaceutical sector to the PE sector to the telecom sector, they have used it very, very extensively. And therefore, let's say, as an answer to your question, like theoretically, what I'm suggesting is that is there an economic or empirical evidence to assert either way? When we say Indians are not aware of privacy, how do we know this, frankly? Somebody at least, sitting in Leeds in UK is doing something, a small data set, they are checking in Indian context. Maybe we can start from there, right? And let's say if we distrust this paper, if we don't like this paper, then let's do a wider study. What prevents us from doing a wider study about India and figuring out whether people are either aware or not aware of privacy? Until we do that, to my mind, I think, as an analogy, I would suppose, and with due apologies to Jacques, it's like Sita's Agni Pariksha, right? Which is Sita's trial by fire. You are asking somebody to walk through fire and prove innocence, right? This is in summary what Sita's Agni Pariksha is, a trial by ordeal. Now, do we want to go back? We might celebrate our mythology and stuff like that, but do we want to go back to Ramayana type of era? Or do we want to create a modern India which believes in rule of law? I would suggest that, if we think of creating a modern India which believes in rule of law, then let's begin with finding that empirical data, that economic data, before we assert either way. That's all I'll suggest as a methodology. But over to Dr. Yadav. Thank you.
Thank you so much, Professor Singh, and thank you, Aditya, for posing a very, very difficult question. I wouldn't say difficult, but very relevant question, but absolutely thrilling to answer, really. And I'll take on from where Professor Rahul Singh left. And so, in my opinion, while Sir is unconvinced about, I do agree that there should be a study to see whether people are even, aware that their privacy is being breached, how much awareness is there. But I would like to assume that, there is a problem that needs to be tackled. There is a problem that exists. We may not even need, I'm sorry to say I'm an academician, but we may, and a researcher, but we may not even need an empirical evidence, because you mentioned rule of law, you mentioned it's a fundamental right. Right to privacy and things. So without getting into that, I think we need to understand, first of all, that there is a huge potential exploitative threat that tech giants are posing at the common public, at institutions, at government institutions, private institutions, that are not limited to privacy and economic issues only, which we are discussing, and it has been discussed exhaustively. But I'm saying this only to put the context right, that even the political arena and the democratic values have been affected across the world. And this we saw in the Facebook Cambridge Analytica data breach case, where there was a major political scandal in 2018. I know all of you know about it, but just as a recalling measure. In 2018, we saw that the revelations made by Cambridge Analytica harvested millions of Facebook users' data without their knowledge or consent, and used it for political advertising. So here are people who are simply either unaware or ignorant, or just, for the sake of convenience, we keep pressing on those, smartphones or on our PCs or laptops, whatever is convenient to just move on to the next page without reading the in between lines. So in my opinion, this is a huge threat. And having said that, now I'd like to, before I come to the Indian context, and Jyotiji, of course, is free to disagree. But the US and the EU jurisdictions have dealt with these issues, the privacy issues, at length. And some pointers that I'm throwing at the viewers and to my co-panelists are that, number one, EU and US have looked at issues such as, should competition law be used to address privacy concerns? The basic. Now, the US and the European enforcement agencies have taken various different approaches in the same. While US enforcers have relied on an adversarial litigation process to vindicate antitrust concerns, mostly guided by consumer welfare standards. And European enforcers, on the other hand, have relied on regulatory enforcement, mostly guided on a desire to protect effective competition, consumer choice, and lower prices. So the intersection between privacy, big data, competition has led US agencies to create task forces to study this tension. And I think I'm going back to a private conversation that I had with Professor Rahul Singh earlier in the day today, where we were thinking that, probably, again, directing to our CCI representative, that maybe a market study is needed to study this tension, and using competition law to vindicate privacy interests would make it harder for innovative companies to thrive with new products or technology-based offerings. So this could potentially result in less competition. Now, many in the United States also believe that it is not an antitrust issue if a company holds a lot of data. For example, data is not a barrier to entry because it is readily accessible to others in the market, and data changes constantly. So relatively, it has a brief useful life. In Europe, I'd like to say, however, in order to protect both protect deep-rooted privacy concerns and to maximize choice for consumers, enforcers focus on the competitive advantage holding data might confer, and are open to limiting the amount of data that a company can aggregate as well as use. So I can go on and on about the comparative analysis, but briefly, in the end, I'd like to sort of summarize by saying that in the Indian context, I feel that a probable answer to this issue, maybe just a short-term one, may be found in a conjoint reading of Section 60, 62 of the Competition Act, which establishes the Competition Commission of India as a regulator, as an agnostic regulator, and it may assume jurisdiction concerning any sectoral law violations, provided it has a competition angle attached to it, we all know. So it may be interpreted that for future investigations, as far as the Indian jurisdiction is concerned, and as the situation stands, CCI may and probably will assume jurisdiction over any allegations concerning personal data breach. But we also need to look at the data protection bill that is there and whether that is the appropriate forum. So these are just some thoughts that I've left at the audience to ponder over. But yes, it's a huge issue. It needs more, thought and a lot of policy, think tanks that should, sort of ponder over this issue. More studies, market studies needed. This is my 2-bit about it, and I'd like to hear from my co-panelists. Thank you.
So I have a question in similar vein. I can see a hand is up. So Professor Cremer, you first. You're on mute, Professor Cremer. Professor Cremer, you're on mute.
Yeah, I'm even more interesting when I'm muted. I think we have to remember that data is two things, okay? Data is a good thing because data is productive, okay? So in terms of competition law, we have two objectives, okay? One objective could be to share data, saying it's true that a big firm like Amazon has got lots of data, but if that data is useful and can be productive, my aim shouldn't be to restrict Amazon from using it. It should be to provide this data to other companies, okay, so that they can also provide the services to the consumers, and hence we get more competition. Okay. Now, of course, I'm not saying that this is a general rule and so on, but this view is not a view which is totally without foundation. So I think we have to be very, very careful to keep the balance between privacy concerns, which are actually very, very, and I think the analysis I've seen typically in competition circles of privacy has been a bit too much privacy as one big thing, but actually privacy has got lots of nuances. I mean, I don't care whether a computer, has a picture of me naked. I care whether my neighbor has a picture of me naked. Okay, I mean, privacy is it depends on what you mean exactly. Okay, so you've got to be very careful about not speaking too broadly about privacy, and you have to remember the other aspect, which is that the sharing of data can be a good thing. So, I mean, this is not an answer to any question. It's just a call to really be careful and not to just think about, oh, how do we prevent abuse of the use of data, but also how do we foster the productive use of data. And I think the competition authority needs to have both of those aims in mind. Okay, but why I wanted to change a little bit the focus from entirely privacy to a little bit also sharing of data. And that's, by the way, also very important in the case of industrial data, because there is consumer data, but there's lots of industrial data which is beginning to circulate. And there the problems of sharing of data is also becoming very important.
So based on what you just said and what Professor Yadav said earlier about privacy and data, I have this question. Is it possible, because different jurisdictions have different understanding of privacy, jurisprudence is evolving everywhere, competition concerns have been of different type, the economies which are now so in countries where digital economy is becoming more prominent now, they are facing new kind of challenges compared to a lot of other economies where they were already existing. I think it is possible that the kind of competition laws which are required, the regime which is required, needs to be contextual to that particular nation. So my question basically is to you and to Ms. Jyoti Bhanot, that is it possible? What do you think? What are your thoughts? Do we need different laws for developing countries compared to developed countries? Because developed countries probably already are, they have a huge digital economy compared to developing countries where it is just starting out. So your thoughts on it, Ms. Jyoti Bhanot?
Yeah, thank you, Aditya. So generally speaking, the design of laws, including antitrust laws, should reflect the level of economic development of the country concerned, structure of the economy, overarching constitutional framework and culture. And the competition law is also embedded, has embedded, these all these aspects and takes into account in its application. And while application of antitrust enforcement toolkit may vary across geographies and jurisdictions, accounting for peculiarities of domestic economies, extent of internet penetration, role of digital economy in the overall market, the fundamental principles governing competition regulation are by and large in sync and grounded in sound principles of economics, and I think this is the position worldwide. So now, given this extent of globalization and interconnectedness of economies and the blurring geographical boundaries in digital economy ecosystem, so it is axiomatic that digital players would be operating across jurisdictions and have to comply with domestic frameworks. So as long as in their policy making and in their functioning, they're adhering to the fundamental principles, I don't think there is much of a challenge in terms of compliance across regimes. Of course, both in law as well as in application of law, the nuances and the actual situation prevailing in the economy has to be factored in.
Right. Professor Cremer, your thoughts?
It's a very, very difficult question. So I won't answer too much about developing economies because I mean, I don't know enough. I mean, so clearly there is a problem of coordination of competition law. This exists even in the old economy, but it's getting even more difficult in the digital economy. Now we know what happens, for instance, that we have a Chinese internet and a rest of the world internet, in part because the Chinese government, so it's not only competition law, of course, but wanted to control the internet. I think we are all gaining a lot by having a worldwide internet. I mean, I'm very much enjoying being here. It wouldn't be possible if we had segregated internet. So I think it's very important that we try to keep integrated internet. On the other hand, it's clear that different countries are going to have different requirements. And so just one point, okay? When you think about a worldwide network, and I know that there's been lots of debate in India about Twitter and WhatsApp, so country like India might say, for good or for bad reasons, we want WhatsApp to change the way it's functioning in that direction. Okay. It could be a good or a bad idea for India, but that's basically up to India to judge. Okay. The second thing, which is, I think, very difficult, is that once WhatsApp developed this capacity in India, it makes it much easier to use the capacity somewhere else. So, for instance, this has been a problem with anonymity, because once there is the way by which WhatsApp can look at something in the messages in India, it can do it in other countries. And it changes totally the nature of a game in other countries. And I think that those kind of interactions, it's very, very difficult. It's very difficult to have normative statements because, it's very hard for us to know, what is the right level of national rights as opposed to individual rights as opposed to international rights. Okay. And it's also very, very difficult because, and that's one point which I think is very important, this depends also very much on the incentives of regulatory agencies. I mean, it's clear that regulatory agencies, competition agencies have got their own incentives, and in particular, they like to have cases, it's more prestigious to go after Google than after local cartel of, car repair. So we also, but we don't have a good idea of the way competition agencies work. And there's a game between competition agencies at the international level. And I've got nothing to say about it, except that it would be really good if more people were thinking about it and thinking of analyzing that game before we can even propose solution on how it should be played.
Okay, thank you. I would like to know if other panelists have thoughts on this issue regarding the contextualization of the competition regime, depending on the state of economy and the culture of that particular country, and how competition law, and it's a very broad net that I'm casting out there, how competition law would also interact with let's say, privacy laws. There is a bill which is pending. And would this create more issues? Would this resolve more issues? Thoughts? Okay.
Aditya, sorry, I think, please go ahead. Please go ahead.
Yeah. I was just saying very briefly that we all know that CCI is an intersectoral and a cross-sectoral regulator. So the bill will definitely help in smoothing out a lot of ambiguities that exist as of now. But the jurisdiction of CCI would remain, in the basic tenets of competition law. So I feel that the bill will only help us in, sort of regulating all of these big data and sort of, tying the loose ends, and to sort of regulate these kind of issues. And like I said earlier, that CCI is a cross-sectoral regulator, and will always have this, sort of all-pervasive power. And I think it's doing a fine job of, I mean, I'm nobody to give a report card, but, of sort of, regulating where required. But as of now, since there's a gap, there is more to be done by the CCI. Once the bill becomes an act and, it's in place, I'm sure there'll be more clarity in the situation as far as privacy laws are concerned. Over to you, Professor Singh.
If I also supplement what Dr. Abha Yadav has said, so when it comes to privacy, I think a CCI stand also got reflected in the telecom study, which was recently conducted. And in fact, that also addresses the point which was raised by Dr. Rahul Singh. And I fully agree that it is very important to carry out market studies to understand the structure of the markets, because all these issues are very complex issues. The markets are becoming increasingly complex and interconnected. So, and that has been the CCI's endeavor, and as can be seen from the trend in the recent past, multiple market studies are being done, be it in the e-commerce sector, which brought about guidance in the form of self-regulatory guidelines to guide the industry. And the telecom study also reflected on the interface and between privacy and competition law. It brought out that how privacy can be a parameter for non-price competition, and also it can translate into exclusionary and exploitative, abusive conduct. So it's the competition angle which the Commission is seized of and is interested in. It is not to say that other regulators would not have a role, because not every issue emanating out of privacy would have to do with competition. Right. And here I would also like to respond that whenever we are examining the issue related to privacy, apart from the fact that whether the users are aware of the policies, what also perhaps will have to be factored in is the meaningful choice that they would have, even if they were aware of that. To what extent are they in a position to port their data? Can they multi-home? And yes, many of, going forward particularly, many of the platforms may offer these facilities and even compete on that. So again, it's a question which has many dimensions, and every dimension has to be factored in to arrive at an answer. Market studies is definitely one of a very effective tool to understand these issues. But having said that, if we come across an issue which requires intervention, or at least an investigation which would also include empirical validation, I think CCI cannot shy away from that.
I wanted to go back to your developing and developed divide, which I think is what you had posed to me.
That's what I originally started this discussion with.
Sure. So I wanted to respond to that question, which is essentially this actually. So see, so to go back to Jacques' analogy, right? He said World Wide Web, and he also said, fortunately, it's a World Wide Web and not an India web and EU web. I hope I got Jacques right. Now, unfortunately, or maybe fortunately, competition law is only Indian competition law. Similarly, EU competition law is only EU competition law. And US antitrust, as they call it, is only US antitrust, right? Why is that so? Because you will see each of these jurisdictions, they have acts as well, so long as you are exporting cartels, not a problem. And this is something which is true of both US and the EU as well. They're looking for impact in the US market. They're looking for impact in the EU market. So until we get an international competition law, which I don't know whether we are going to get or not, I suppose the reality is that this is going to remain an Indian competition law, right? And given that the goals of competition law might be vastly different between US and the EU and India, I would imagine that it would be worthwhile for us to think about what is the goal of Indian competition law and stick with it. It might also have another advantage, by the way, which is this. If we are going to live in a world which will have international competition law, this will be like cricket, because British now regret the day they taught us cricket, right? Hopefully a day will come when Westerners will regret the day they taught us competition law.
Yeah, I mean, but that requires an international regime, right? For that to happen. Because as you rightly pointed out, competition law regulates only how effects are happening in your own economy. It is not bothered if actors within your economy are having a negative impact on the supply of goods in some other economy. But as you said, that we don't know whether that international regime is going to come or not. But that's still...
Can I just have 2 words about this, please? First, you get to remember there's huge amount of international contact for the internet. So what India does for controlling the platforms within India affects Indians which are abroad, affects me when I'm connecting with India and so on. So that it's not as clearly cut off as different points. Okay. And secondly, look, we're not going to get an international competition. On the other hand, I think it's relatively important if we want the internet, and the digital economy to function well, that people do think in terms of, how do our, each country has got its legitimate interest, but also has got an interest in the fact that the overall system functions decently. And I think that's why, all the organizations which help contacts between competition authorities, for instance, the IICA and the International Competition Network, and there are a number of others, are really important because, competition lawyers and economists speak a little bit the same language all over the world, and they can, in some sense, translate the worldwide problems into local language and back and forth. So I think there are things to be done, short of a formal international framework, and those things are very important.
In fact, I have a question, and anyone can take this question. And this is related to what Professor Cremer had spoken about earlier, that digital economy is a new kind of economy altogether, which is different from how it used to be earlier. And this digital economy is also more integrated. It doesn't always abide by territorial boundaries. So is it possible that national competition laws may not be able to respond to the challenges which are arising unless and until they decide to come together to regulate this digital space? It's an open question.
Okay, before you put us on the spot, I'll go ahead, right?
I was going to cold call on people. Yes, thank you.
Right, I thought that might not be a good idea. But anyhow, so here is what I think. See, so this is something which is not unprecedented, by the way. This is a question which you raised at the beginning as well, that digital economy is new and nobody responded. Probably that's why you are raising it again.
Yeah.
See, at the time when Sherman Act came about, of course, our institutional memories are always short, right? When Sherman Act came about 1890, railroads raised an exact same question, and they said, well, we are railroads, how can antitrust law apply to us? We predate antitrust law, and therefore you should think about a new legislation for us. So it's not very unprecedented. It's not a novel question to suggest that, digital economy companies think similar. But you see, I mean, this is the idea of law, right? Laws are supposed to be sector agnostic. Professor Abha Yadav has mentioned this, right? Particularly competition law. The commission is sector agnostic, right? And this idea that, there is this set of laws which will apply to all of these entities. And maybe this also ties with what Jacques was mentioning, which is, you see, short of international competition law, there is a common language which has come about, the law and economics based language, and the point is quite well taken. If I may add, there is also International Competition Network, the virtual office, and Indian Competition Commission participates very actively in International Competition Network. So of course, this is not to suggest that conversation is not going on already, right? And therefore you see, I mean, the fact that, certain companies might feel that laws do not apply to them is not really the end of the world. Of course, every new company comes about and thinks that laws will not apply to them because they're exceptional. Tomorrow we are going to have this very exciting session on blockchain and artificial intelligence and whatnot. I wouldn't be very surprised if cryptocurrencies or these entities which do bitcoins, they feel that no law should apply to them at all. Forget about competition law because they're a new kid on the block, right? And therefore this is something which is not unprecedented is the point. These arguments have been raised earlier in the US context. At least the US Supreme Court has addressed them, suggested in the negative because antitrust law is supposed to be sector agnostic. And therefore, I'm not sure whether we should reinvent the wheel and say because digital economies are sort of a different kind of companies, therefore the entire law should change lock, stock and barrel. That said, there was a point which Dr. Abha Yadav mentioned quite a while ago, and if I can go back to that. She said, there is this draft, let's say, Data Protection Authority bill, right? Now, that said, it also means that we should await, let's say, an expert or expertise-based body like Data Protection Authority, which will come about and possibly look at some of these digital economy questions in greater depth than maybe right now what we are interested in as a society, right? And therefore, you see, of course, when we are talking about competition law, we may try to ignore other authorities and other legislations. But the idea is that each of these regulators have to work together. In fact, I should not say too much on this. Dr. Yadav is the director of FOI, the Forum of Indian Regulators. It's her job to nudge each of these regulators to come on a sitting table and just talk to each other, right? And that's something which I suppose is important for not just the international, or let's say at the international competition network, for the competition agencies to talk to each other, maybe domestically as well, the competition authority, the data protection authority, whenever it comes about, other regulators like RBI, it might be useful if they start talking to each other. Maybe some of these questions may not emerge if they just talk to each other.
So here, let me just supplement by saying that our regulatory framework already provides for this kind of an exchange and coordination and cooperation. And in fact, the CLRC, which had submitted its report, has given recommendations to further strengthen that. And let me put on record that CCI regularly does these kind of exchange with other regulators. And there's no doubt that going forward, a coordinated approach and a committee between regulators is very much required to fully appreciate the scope, the bandwidth of the issues, and to ensure an effective and efficient regulation.
Right, but I think the larger point was that not just CCI should take initiative, all the regulators should take that kind of initiative to collaborate.
So fortunately, this framework, it is a reciprocal framework.
Right.
And the law has been so futuristic and so enabling that actually it has factored in all these possibilities. And more than that, it also is an approach and how you build in a confidence amongst the regulators, which Dr. Yadav has been given the responsibility of.
So I just wanted to precise, I'm not saying that there is no coordination. I'm relatively new in the field of competition law. I just wanted to say it's very important that there is cooperation. And I've been since I've been looking at that world, I've been very, very impressed by the way in which there is discussion among the competition law agencies all around the world. Okay, so it wasn't what I was saying wasn't a call for something which didn't exist, was a call for it to be strengthened and expression of admiration for what people are doing on this topic.
Right. Thank you. Thank you, everyone, for your thoughts and insights. There are few takeaways which I would want to repeat here. One, and of course, there were differing views also. So I think more research we need to do on our own to figure out what stance we would like to take. So of course, there was this view that digital economy is different from what economy meant earlier. It has brought in a new dimension which doesn't understand territories, and therefore the challenges are new. And then we had, if I may say, an opposite view that it's basically the same old wine in new bottle, and you just need to understand that. And the moment you figure it out, the problems can be dealt with. Apart from that, data was discussed not only as something which could lead to competition concerns, but how these competition concerns are also related to, let's say, privacy concerns, how they may be context specific. When I say context, these are national context, cultural context, etc. And also we had this example where we discussed that data is not necessarily bad. Data inherently is not bad. And when we discussed the GEM example, data can actually be put to great use as well. So these were some major takeaways for me, and I hope they were also major takeaways for you. Thank you so much, everyone, for being here with us and sharing your views and thoughts and making us wiser about this topic. Thank you.
Aditya, can I ask a question to Mr. P.K. Singh on GEM?
Okay, sure.
Please go ahead.
Yeah, I wanted to ask you whether, have you seen any kind of impact on the small and medium enterprises participation in public procurement after GEM has come about?
I think there's a network issue.
Okay.
I'd like to extend my warm thanks to the organizers as Mr. Singh joins back for having me over. And I think I've written in the chat box also, I think we all, it's an unsaid that we all are here because of all the wonderful data that exists and how to protect it and how to make sure that the privacy of all of us and, most importantly of consumers who are absolutely ignorant, who do not know. I mean, there are children involved, and especially in a country like India where we are so unaware, largely our population is unaware of what is happening. They're only in it for the services and they don't know. I mean, we are at an intellectual level discussing the high level issues. But trust me, and I think you all know that majority of our population is not aware of these kind of issues. For them, it's just a service that you take and that's about it. So I think as policymakers, academicians, all of us are discussing it, and thanks to the wonderful participants, more than 100 who've been with us throughout, these kind of brainstorming sessions are absolutely a must. Thank you so much to the organizers and to Professor Rathore for being such a wonderful moderator. And thank you to my co-panelists. Thank you, all of you.
Thank you.
Thank you very much.
Sentiments.
I'm not as eloquent as you are, but I wanted to second those feelings because lots of fun, and I hope that someday we meet in person. That would be lots of fun.
So, compliments to your team.
Thank you for being here. Please go ahead, Kabir. I think you want to propose a vote of thanks.
Yes, sir. So, sir, as we have approached the end of the discussion for today, I would like to take just a brief moment to extend gratitude to everyone behind the successful completion of today's congregation. On behalf of myself and LTech, ACLA and NLSIU, I extend my sincere gratitude to Honorable Mr. Justice S. Ravindra Bhatt for his enlightening keynote address, which robustly heralded the start of our summit today, laying the foundation for this vibrant and worthy exchange of ideas. I thank Professor Rahul Singh for his sharp insights in the discussion and helping make Consilience 2021 possible. I also thank the other extremely learned panelists, Professor Jacques, Professor Abha Yadav, Ms. Jyoti Jingar Bhanot, Mr. P.K. Singh, for their diverse and enriching perspectives in the discussion. The credit for tying the confluence of ideas in this session into a singular whole goes to Professor Aditya Rathore, who skillfully moderated and navigated the discussion. Finally, I would like to thank our valued attendees who enriched and contributed to the discussion with their valuable queries. I trust that it was a beneficial experience for all attending the event, and allow me to remind you to kindly fill in the feedback forms, which are accessible through the link in the chat, so that we may incorporate your suggestions towards future events, and also send across your certificates as a token of our appreciation and a memento of the event. Thank you, everyone, and we look forward to seeing you in our other sessions over the coming 3 days as well. Good evening, and until next time, this is Kabir Jay, Joint Convener of LTech, signing off.
Thank you.
Thank you. Thank you, everyone.